Hello, it's Philip Taylor speaking from Richmond Green Chambers. I'm looking at this book from Informa. It's called Arbitration Law Handbook. It's edited by Ben Horn and Roger Hopkins. You can see the side. It's 1,000 pages long. It's a heavy book. It's a paperback, so you do get it covered, plasticated, because it will take a bit of wear quite quickly. There's a useful contents page right at the beginning. Then you go straight into the articles and the rules for the various jurisdictions all the way through, and right at the end you've got a very detailed index. It's a heavy book, so be careful with it, because as I say, it's a little bit flimsy as a paperback. My wife and I have written a review. We had a look at this book and a good chat about this and some of the other arbitration materials around. We've given it the title Arbitration Laws in Over 20 Countries in One Handy Handbook. What we say is that in today's global commercial environment, international arbitration has emerged as an important safeguard for investors. Therefore, the need for a definitive work of reference on arbitration, mediation and adjudication rules is immediately apparent, and this assistance is what the editors of this ADR volume amply provide, as more and more disputes are resolved in this way in preference to the courts, very much in keeping with the thinking of the higher judiciary here. So if you're an arbitrator or arbitration lawyer involved in resolving cross-border disputes, you need this book for its rules. The rules obviously are very heavy. The articles are set out and the specific rules are in there. It looks at cross-border disputes, as I say, particularly if the seat of the arbitration is in a country or jurisdiction other than the one in which you are qualified. In this sense, as the authors point out, the practice of commercial arbitration is unique in that lawyers in one jurisdiction may often conduct arbitrations in another. It's interesting because you don't get that in any other area of our procedural activities. This is one convenient volume, therefore, which contains the arbitration laws of over 20 countries, namely 24, Australia, Austria to the Ukraine, UAE, UK, USA, as well as the main procedural rules used in each. If separate maritime arbitration rules are in place, these are also included, and of particular help, or for people that are confused like us, is the overview section, which I mentioned at the beginning of each country. We have this little overview which tells you about the actual country itself, and I'll just find a particular one. There we go, there's Hong Kong. You've got a complete overview there. It's extremely useful because it sets the scene on the rules. The international section sets out in its entirety the unique trial model law, which has contributed greatly to the harmonisation of laws of international commercial arbitration. Also, there's a wealth of other material, including the ICSID arbitration rules, and obviously they apply to the settlement of investment disputes. There's also WIPO, looking at intellectual property disputes. The index, as I mentioned at the back, is particularly useful as a feature because it's a good shortcut when you're looking up, especially specific rules, in this what is actually going to be an indispensable paperback, although, as I say, it is a little bit flimsy, so be careful with the side of it. For shipping lawyers, including in-house lawyers as well as arbitrators and dispute resolution lawyers, anybody involved in negotiating cross-borders contracts will find this handbook a must-have work of reference, no doubt about it. As the authors rightly say, the importance today of international conventions and agreements relating to international arbitration cannot be overstated, so this handy handbook ensures that they are not, with a wealth of detail, so well set out anywhere else. So thank you very much to Informa and to the authors. Bye bye.